Hello and welcome to Dialogues Q&A, where we invite queries from members, startups, founders, and get an expert on board to answer those queries for you. And today the expert in the house is Vanessa Agarwal of Thinking Legal. Welcome, Vanessa, and I'll dive straight into the questions. Now, one of
Thanks,
our
Trisha.
members has asked, how can we have equity share division in LLP?
So actually, Bushra, whenever we meet anybody who is thinking of starting up, the first thing we tell them that you should incorporate as a private limited company if you want any third party funding, because to do an equity division in a partnership is not possible. All the partners can contribute capital, and if you have an investor or a third party coming on board, what can happen is that they can become a partner in the LLP and they will contribute capital. Profit sharing can be either in proportion to the capital contributed or in any other mechanism of profit sharing that the partners agree. But it's not possible to really do an equity division in a LLP. We have seen institutional investors and even other investors being quite hesitant in becoming a partner in an LLP, because as an equity shareholder you do have very limited liabilities when you become an equity shareholder in a private limited company as compared to becoming a partner in a LLP. Also, most fund documents don't allow institutional investors to become partners in an LLP. So one, I think, is not possible from a LLP Act perspective, and second, even practically, it is not something that investors are keen to do.
Okay. So the next question is, how does safe documents work to raise funds?
So, SAFE is a very popular instrument. It was used by Y Combinator in the US originally. And in the past few years, we have seen SAFE instruments come to India as well. It's popular, especially for the first round of funding, where neither the startup nor the investors are really sure of what the valuation can be, because the startup is at a very nascent ideation phase, or they have just started with their proof of concept. So what a safe note does is that it kind of defers that valuation, and the safe note holders typically get a discount to the first round that is raised after the safe note is issued. While this is the way that the document of SAFE works, in terms of the Companies Act and Secretarial, SAFE notes are also issued as compulsorily convertible preference shares, or CCPS. So the issuance mechanism under Companies Act is the same, and the primary difference is that the valuation is deferred, and there is a document called a SAFE document, which is executed with the investor to do a SAFE funding.
Okay. Okay. So the next question is regarding an employee contract. So if a contract stipulates NDA that and not working with the competitor for 12 months after leaving, the job, but if the employee leaves and joins the competitor right away, then how can a company, enforce the contract?
So, I mean, the enforcement of contracts has to be done through some sort of legal procedure. Typically, there is a lot of talent war going on in the Indian startups. We have seen a lot of employees, even at senior levels, join competitors despite this restriction. Companies typically send out a legal notice to start with. So a legal notice is something in which a lawyer or a law firm will give notice to the employee that, what you're doing is not right. It is not in accordance with the contract that you have signed. And they will ask the employee not to either join a competitor, or they may even ask for some damages. The challenge is obviously that once the employee joins a competing organization, it is not always easy to kind of convince the employee through a legal notice to leave the organization or take a break of 12 months. In that case, one has to try to then file a case with the courts to get enforcement. There is something called an injunctive relief, which is possible. An injunctive relief is one in which the courts will order the employee to stop working with the competitor. These reliefs are possible, but they are not very common. Courts generally frown upon, and there is a section under Indian Contract Act which does not allow these non-competes to be very readily enforceable. So a non-compete is typically not easy to enforce. On the contrary, a non-disclosure agreement, if you can prove that the employee has actually given out some confidential information, that is something that it is possible to get relief from. But generally speaking, the law in India is quite pro-employees. So unless the employee is, say, a founder or something, if it's just a senior level management, the courts tend to be very employee friendly, and it is not easy to get relief from courts.
Okay. So the next question is also somewhat related, that why is an individual legally not permitted to undertake two or more jobs as long as neither of the assignments are competitive in nature?
So, I mean, there is no express restriction under the Indian laws about taking two or more employments, especially if you are in any kind of, job where the minimum salary per month is more than, say, 15, 20,000. Because under these salaries, there are Factories Act or something that may apply. So, for example, under Factories Act, the workers are not supposed to take one or more jobs because the law tries to protect the fact that some employer might misuse this and set up two companies and make an employee work more than one shift. So besides that, if the both the employers are okay, it is possible to do two types of jobs. Typically, employers are not okay with this arrangement, and that is why there is an exclusivity in every employment contract that is there. And every contract does have some non-compete exclusivity, that you cannot work with anybody else than a non-compete that we mentioned, that you can't work with a competitor. But if both your people that you want to work with are okay with it, there is no express restriction under any law that you can't do it, except, as I mentioned, some of these Factories Act, etc., might have a restriction. But depending on the type of job, most of the times it should be okay.
Okay. So one member has asked us that they have a payment of 1 lakh stuck with a vendor. Now they've been chasing them for 5 to 6 months for the same, and the client is saying that they can only make the payment once they get it from their vendor. So what's the way around it?
Yeah.
What does a party do in such a case?
So, Bushra, again, we work with a lot of startups. We feel the pain when the startups are not able to get payments from parties. You mentioned that the member has said that the amount is 1 lakh. Now, the challenge is that if someone is unwilling to pay, the only way to kind of get remedy under the legal process is to start some sort of, either you send a legal notice or you file a case or something. Anything that involves any legal intervention is obviously something that you will have to pay an external lawyer to do, unless you have an in-house lawyer from your startup which can do something. If there, when you're dealing with vendors, obviously to have watertight contracts is very important. Once you have that sort of contract in place, there are still times that people will not pay. In those cases, it's possible to get some relief from, say, consumer protection court, depending on the type of relationship that you have with them. If you are an MSME, there is also a mechanism under MSME Act to get some relief or file a complaint. Otherwise, the contracts that you may sign with your vendor also might provide a dispute resolution mechanism. So there may be an arbitration that is provided, or there may be some courts that have jurisdiction on that dispute. So as the first line of defense, one, again, typically people send a legal notice. After the follow-ups, legal notice might kind of hasten the process of getting the vendor to pay. And after that, if that still doesn't work, then one has to evaluate if filing some sort of legal procedure, what is the cost of doing that, what is the timeline that one is looking at. Because even if you have a watertight case, there is still some time lag between filing the case and the case being decided. So one has to see what that timeline is and how that can be worked out. But if the repeated follow-ups are not working, I would then suggest to send a legal notice, because that sometimes does kind of put notice to the other side that you are serious about pursuing your legal options.
Thank you, Vanessa. Thank you for your time. Thank you for answering these queries for our members.
Thank you so much, Bushra, for having me.